Sharna Lee from the IIE, and you can proceed to share your screen and present, and I'll give you 20 minutes.
Thank you so much. Let me just share my screen with you. Okay, you should be able to see. I'll show my face for a second. Yes, it's my name's Sharna Lee, and I am currently a PhD student at UCT under the supervision of Professor Danwood Chirwa, and I'm also the Deputy Head of the School of Law at the IIE's Varsity College. So good afternoon to everybody. I unfortunately couldn't be there in person, but I'm very grateful that I can still present virtually from a very cold and chilly Cape Town. And just yeah, a lot of the people in the room today are the people whose work I'm up reading at all hours of the night for my thesis. So I admire many of you, and it really is a wonderful privilege for me to present to you today. Not intimidating at all. Just some background to this topic. This was originally a topic that I wanted to pursue for my thesis, and as things go, my thesis took a different route, still looking at the best interests of the child, but in a different light. But this is still something that's quite close to my heart, particularly as a brown girl from the Cape Flats in Cape Town. It's something that I'm quite passionate about. So today I aim to take you on this journey with me, looking at, where South Africa came from, where we are now, and what I envision for the future application of the best interests of the child in our courts. Just as a disclaimer, this is a work in progress. It's not a completed paper. It's really just at this point an idea and something that I would like to pursue. And I also do have load shedding. My battery hopefully will last through the presentation, but if I disappear afterwards, you know what has happened. So for centuries, children were often treated as property with few, if any, legal rights. And then this reality started to change in 1924 with the Declaration of the Rights of the Child, which really marked the beginning of the children's rights movement. And it recognized the vulnerability of children and the need for special protection. Over time, of course, this concept evolved, and it was influenced by shifting attitudes towards childhood, the growing recognition of children's rights, and changes in the family structures. Then in 1994, of course, South Africa became a democratic society, and the next year in 1995, we ratified the UN Convention on the Rights of the Child. And of course, by doing that, we then became obligated to domesticate the CRC and develop our children's rights in line with its provisions, encompassing civil, political, economic, cultural, and social rights. And most importantly, I think the CRC recognized children's rights as human rights, and it marked this shift from viewing children as needing special protection to recognizing them as individual rights bearers, entitled to a full basket of rights. So the best interest principle, which was once a mere welfare principle, transformed into a tool applied in all matters concerning children. Then, of course, we have the African Charter on the Rights and Welfare of the Child, which is our regional instrument. And this is a very important instrument for us in South Africa because the CRC was criticized and critiqued in Africa for its Eurocentric focus and its failure to consider the unique circumstances of the African child. And that was partially due to the fact that during the drafting of the CRC, there was very little African voice involved. So factors like poverty, warfare, and cultural beliefs that make African children even more vulnerable were not always considered. So the African Charter was adopted, and it addresses these specific issues and gives voice to the African context. In terms of South Africa, we know with our apartheid history, with the gross violations of human rights and children's rights, children weren't passive victims of apartheid. They were actively joined to the struggle and exposed to trauma, discrimination, and the ever-present threat of violence. The apartheid system was built on unjust laws and policies. It segregated children and their families by race, and it created a very different reality for South African children. As I said earlier, these were not children that were passively involved. They resisted, they marched, they protested against these injustices, and they often paid a very heavy price, with some of them even losing their lives. So although these gross human rights violations occurred years ago, and it's 2023 now, I think that the emphasis, or they emphasize the importance of a human rights approach to the child's best interest in South Africa, in recognizing children as individual human rights bearers. I think it's crucial to do this so that we ensure that these violations can never occur again. So what does this look like in South Africa now? Of course, in our post-apartheid South Africa, we've made significant strides to protect children's rights. We have one of the most progressive constitutions that don't only give children the Bill of Rights and the full basket of rights that all adults have in South Africa, but they even have specific rights just for children. And in 2009, the UNICEF report lauded South Africa's progress in addressing apartheid-era violations and embedding children's rights in the Constitution. We then also have the Children's Act, which further solidified these rights, addressing the gaps in laws and ensuring reciprocal rights for children and parents. So what is this autochthonous best interest principle that I talk about? Some may say a decolonized best interest of the principle, a term that I prefer. I feel is less controversial or has less of a sort of political agenda, is recontextualized. So what I'm really trying to argue for is a recontextualized best interest principle. And in understanding the child's best interest in both South African and international contexts, I think it's very important for us to consider this historical development, because initially we know that the principle emerged because children lacked their own human rights. And so it served as the standard that would safeguard the child's interest. However, the application of the best interests of the child in courts often became paternalistic and sometimes even charitable. So the term autochthonous refers to something that is native or indigenous to a specific region or context. And in the context of the best interest principle, it signifies an approach tailored to South Africa that considers South African children's cultural, social, and real life circumstances. An autochthonous best interest principle is one that values cultural diversity and adapts the concept to a child's unique cultural values, their norms, and traditions. And it acknowledges that distinct factors influence a child's well-being in different contexts. So ultimately, the approach really respects each child's individual context by protecting their holistic well-being and dignity, by protecting the whole child, emphasizing the child's individuality and autonomy, and thereby ensuring their dignity. And it safeguards the holistic child, the whole child, because we're looking at all aspects of the child, the social, the emotional, the physical, and the mental health of the child. So why? Where does this come from? I feel like the Eurocentric influences in international law have shaped children's rights discourse in South Africa in ways that don't always consider cultural diversity and can sometimes perpetuate colonial legacies. And how does that happen? What are the remnants? Are there remnants of colonialism in our best interest principle? So like I said, while the country's made significant strides in post-apartheid years to establish a more inclusive and equitable legal system, there are certain aspects of colonial history that still continues to influence how the child's best interests are interpreted and applied. So we've got phenomenal legislation, I think. Our Children's Act is exceptional at addressing the child's best interest with the Section 7 list. We've got, and of course, the Constitution as well. But these remnants of colonialism can often be found in cultural biases and assumptions. So, the historical colonial attitudes and biases have left an imprint on societal perceptions and norms. And these biases can affect how individuals, including legal and social welfare professionals, interpret what is best for the child. So we know in the court process that this best interest determination is one that happens with a multidisciplinary team, but often that multidisciplinary team could unknowingly have these cultural biases and assumptions. The preferences and customs of certain cultural or ethnic groups might be misunderstood or overlooked due to lingering colonial perspectives. Then, in terms of representation and participation, colonialism, we know, marginalized indigenous communities and suppressed their voices. And in the context of the best interest of the child, certain communities might still struggle to adequately be represented and heard in decisions affecting their children, or the children themselves may struggle to be heard. And just in a practical sense, I think, that comes down to sometimes not being able to articulate themselves or not having the confidence to voice their opinions and their views. So this lack of representation can impact the ability to truly understand and prioritize the cultural, social, and economic context of these communities. And then linked to the first one, the cultural competency of professionals. So we know that the determination happens with a family advocate, family counselors, social workers, psychologists, magistrates in the children's courts, and judges in the High Court. And these professionals working in these fields, they might lack the cultural competency or awareness of some of the injustices that could lead to biases and misunderstandings. It could affect how they assess and determine the child's best interest. It could affect how they apply the other rights of the child. And then, of course, language and communication, particularly when we deal with indigenous languages and cultures. Language barriers can impact the child's ability to express themselves, express their views effectively in court. And then lastly, the power dynamics. Colonial histories can contribute to ongoing power imbalances in society. And these imbalances can affect the ability of children and their families to advocate for their best interests, particularly if they belong to those marginalized groups. So what do I propose? Where am I going with this? So I think decolonization is a multifaceted concept, and it encompasses key aspects. So like I said, I prefer to use the term recontextualizing the best interests of the child than decolonizing. And I think it involves a critical examination of colonialism, and which can sometimes be overlooked in mainstream discourse. I think it offers alternative perspectives and approaches to addressing issues that are rooted in colonial legacies, recognizing the diversity within this. So I think that, decolonial theory emphasizes decentering Western knowledge and worldviews, and it challenges dominant Western narratives while acknowledging their relevance. So instead of erasing them, it calls for an inclusive approach that allows diverse cultural, political, and social perspectives to exist. So I think that recontextualizing the child's best interest requires scholarly efforts. As researchers, it includes knowledge generation, research as lecturers, teaching, and an intercultural exchange. And this process aims to diversify knowledge production, challenge the Eurocentric historical context from which prevailing ideas about childhood originate, and really promote inclusivity in legal education as well by equipping our students with the ability to engage with diverse social realities in a globalized world. And that in turn gives them a broader perspective on how the world functions. So this, and I think that the challenge with the best interest of the child principle lies in a warning that was issued by Justice Sachs in S versus M in 2007, when he cautioned the courts against the misuse of the best interest principle or applying it too thinly. And I think that this principle has often become one, it has the potential to be overused. It's often invoked without clear guidelines, which can dilute its significance. So while it's accepted as crucial in child-related matters, it can sometimes overshadow the substantive rights of the child that could better safeguard that child's interests. So to address this issue, I support an argument by Nigel Cantwell, which was supported by Anne Skelton in an article that she's written about a threefold human rights approach where the best interest principle serves as a subsidiary principle, a secondary principle, and we first apply that full basket of rights for the child. And I think that ultimately when you do that, by default, you are ensuring the best interests of the child. But rather than the focus being on the child's best interest, which can sometimes be subjective, we apply all the rights of the child first and use the best interest principle to support that. Or when we are in a situation where we need to balance competing rights, then we can rely on the best interest, or to fill gaps when the child's rights are not, don't offer adequate guidance. So an effective system that applies the best interest principle follows a human rights perspective, I think, and it prioritizes the child's rights. It respects the African context, including that child's dignity, non-discrimination, equality, and autonomy. And it's tailored to the specific circumstances of that particular child. And that for me is a recontextualized autochthonous approach. It's one where the best interest is secondary, it's subsidiary to all the other rights of the child, and we consider all the rights of that child. We will, in essence, as I said, be protecting that child's interests. We focus on the child as an individual rights bearer. So next steps, as I said, this is really in its planning stages. It's a lot of ideas at the moment, and I feel like it definitely needs more interrogation from me and perhaps looking at other jurisdictions and doing a bit of a comparative study. And then something that I might be late to the party, but I just recently discovered TWAIL, the Third World Approaches to International Law. So that's something I'd like to explore and have a look at. And then I think just continuing further research and placing more emphasis on the African Children's Charter, and then further research and knowledge generation and transformation, even in our teaching and learning strategies, that are, to teach our students to look at things in a different light and to consider those power imbalances and to consider those historical colonial legacies, and to continue having the hard conversations. I don't think it's ever easy to talk about colonization and things like that. It can sometimes be quite difficult, but I think we need to continue having those conversations. So thank you to the organizers and attendees for listening and for this opportunity. And I think if I could leave you with one last thought, to ensure that every child's best interests are upheld, I think that we need to remember that it takes a village. And I know if you have kids, people always say it takes a village. But nobody's up at night with me when my baby's awake, so I don't know where the village is. But I think in respect of children's rights, we are that village. And I think that we are that village to protect their unique identities, their rights, and their well-being. And it's our responsibility that we share. So I think let's continue doing it, and let's build a world where every child has a voice that's heard and their rights are all respected and their futures are cherished. Thank you so much.